Thank you, Ms. Cannington. It is March 29th, 2022, around 9:40 a.m. This is a deliberation of the Baltimore County Board of Appeals in case number 21201 SPH in the matter of Fazal, LLC for 8202 Pulaski Highway, involving petition for special hearing and variances. We are here deliberating a request for a continuance by the protestants. The Rosedale Community Association and Russell Mirabile, their president, who was having some of his own technical difficulties at our hearing on March 16th. I believe Mr. Mirabile has been in touch with the board and is, I think, coming up to speed on finding a way to join us in the technicalities should we continue the hearing. So it is my inclination to grant the continuance. We want as much participation as possible, and these have been really challenging for a lot of people. So that would be where I'm coming from. Mr. Lauer, you have an opinion?
Yes, ma'am, I do. I'm wondering if we can solve this by asking Mr. Mirabile and the petitioners to submit a memo. He could then include his exhibits with that memo, possibly, and then we could move to deliberation possibly a little sooner. I don't know if that works or procedurally that works, but that was a thought I had after the letter was received that I looked at from the 16th.
My concern is that he is pro se, and that puts an additional burden on him. Mr. Sampson?
Yeah, I think that the continuance is warranted here for the reasons that I think explicitly, but perhaps implicitly stating at the hearing. I don't think that a memorandum would cure or substitute the right to call witnesses and to cross-examine Mr. Doak. I think that Mr. Mirabile is entitled to use exhibits of his own in his cross-examination of Mr. Doak. Anticipating another issue with Mr. Doak, I think Mr. Doak has to appear at the continuance just like he would and did appear at the initial hearing. He's subject to cross-examination. He's still in the case in chief of the developer. The quirk here is that we moved beyond that in order to complete remaining parts of the hearing that day, subject to a decision on how to handle Mr. Mirabile's inability to present exhibits that day. So I'm sort of going a little bit beyond just the continuance because this issue came up about payment and subpoenas and so on. And it's my view that, like any continuance, for some reason that day, things got sideways when the developer's lawyer, in my view, made certain objections. He's entitled to do, but I think the appropriate response in that regard is Mr. Doak needs to appear. So if his calendar needs to be coordinated, fine. That's at the expense of the developer, just like when the developer puts on his case. The only thing different is we're taking a cross-examination out of turn. And Mr. Mirabile is entitled to use his exhibits. We will address issues of each exhibit in my view, as they arise. And for example, for guidance, where we went sideways on Mr. Mirable attempting to ask Mr. Doak about the authentic signature of whomever. I think it was a neighbor, but it's not important. I think for the deliberation, the important point is Mr. Doak can be asked if he knows if that's an authentic signature on the document that Mr. Doak relied upon. And he can say yes or no, and he can say the basis of that. Mr. Mirable then, in his own case, can put in whatever exhibit he has to suggest that the signature is not authentic. But we're not going to get in. We shouldn't be getting into a situation where we have Mr. Mirable and Mr. Doak arguing over foundations of exhibits. Mr. Doak either does or doesn't have familiarity with the specific signature, and Mr. Mirable either has or doesn't have his own testimony or exhibits or witnesses to challenge it. So I think we have to have a continuance. I think that Mr. Mirable is entitled to that cross, and then he's entitled to put on his own witnesses and exhibits. And that's how I would rule.
And I concur.
I concur also. I was only confused by the letter that said he agreed to Rule 8. I didn't quite understand what that meant in the letter, but I do concur with both of you.
I'm guessing
Sure.
here. I think I'm totally guessing, but I think Mr. Mirable made it clear at the prior hearing, his displeasure with the process and this suggestion that he had to himself use technology to present his exhibits, and that had we been in a courtroom, he would just present those exhibits. I think what he was saying in his letter is he now concedes that he will comply with the procedural method of these Zoom hearings, and that he will present his exhibits electronically. That's how I read it.
Okay, great.
So with that, we are in agreement to grant the continuance. We will ask Ms. Cannington to try to coordinate that with Mr. Doak and Mr. Mirable and the petitioner's attorney. And we will continue the case at such time as schedules are put on, and we can do that. And that concludes this deliberation. Thank you, Mr. Sampson. I'm sorry that we didn't get to see your face today, but we're happy you're here. And thank you, Ms. Cannington, and everyone for attending.
May I just add one more thing? I'm sorry. Just for balance, I don't want the developer to think that this is solely about Mr. Mirable, but you did mention pro se, and I think we're all sensitive to timing and delay and cost and expense and the need for decisions that the developer has an interest in. So I don't want the developer to think there's a slight there. The unusual nature of how this hearing began and proceeded has captured more of the attention. But I do think that Ms. Cannington, as always, will attempt to get this in as quickly as schedules can coordinate, and there's no disrespect to the developer's position in that regard. So sorry, Chair, I just want to make sure I said that.
No, I appreciate that, and I'm glad you made the point. So thank you again. And if that's all, I'm going to ask Ms. Cannington to end this event.